You have questions, we have answers. This is Jane Muller.
And this is Ken Muller. Welcome to our show, all about real estate with Ken and Jane. Today is part 2 of Landlord Tenant class, and as our teacher / attorney, we have returning with us our guest Craig Rothenberg. He's a local attorney in New Brunswick. Craig, welcome back to our show.
Thank you very much. I'm very happy to be here. I got to tell you guys, I'm just having flashbacks. When I was a little kid, my father owned a restaurant in the Brunswick Square Mall called Bun and Burger. I think it closed around 1995, and when I was probably 8 years old, I think I came to this studio and we recorded a radio commercial. So this is the first time I'm back or ever been on the radio. So I'm honored to be here.
You see all that experience when you're 8 now. A couple years later, it's still in the back of your mind. That's pretty cool. Did you grow up in like the Brunswick?
I grew up in Manalapan.
Okay.
I live in Montgomery. And I went to Rutgers, and my office is in New Brunswick.
So you're all Jersey guy through and through, right?
All Jersey guy. Seton Hall Law.
Oh, very good.
Never left.
Yeah, great. Yeah. Well, that law school education has certainly, it shows itself. You're very knowledgeable in landlord tenant, and we had to have you come back because although we covered some topics last week's show, we did not get nearly to cover everything we wanted to cover. So just give a really quick recap what your firm does besides landlord tenant issues. You do what the other services you provide.
It's a general civil practice. We do personal injury work, business litigation. We also do commercial transactions, small business mergers and acquisitions, residential commercial real estate, landlord tenant, basically everything on the civil side. We're usually we're a good office to call for those matters. We don't handle bankruptcy, family, immigration. I just don't have experience in those courts, so I just tend to stay out of them.
Sure, absolutely. All right. So we covered last show. We covered the security deposit. We covered, grounds and means for terminating a lease agreement, and what constitutes damages. So if any of the listeners missed last week's show, please, can always tune to the website to catch that. It was very informative. So this show, we're going to focus on some other issues, and we're going to get more into the litigation aspect of landlord-tenant disputes. So Craig, if you would please talk about certain grounds that give rise for landlord-tenant disputes in your experience.
Sure. The way I like to look at filing for eviction, if you are representing the landlord, because we represent tenants as well, but let's say you're representing the landlord. I look at it as two branches of the tree. On the one hand, you have a non-payment of rent case. On the other hand, you have what's considered a notice ground for eviction. So if we focus on a non-payment of rent case first, let's just quickly talk about that process, because those cases are really, on paper, in theory, the easiest types of cases. Mm-hmm. Tenant misses rent, tenant doesn't pay. Mm-hmm. Landlord does not have to provide any notice to tenant. Landlord can simply file for eviction, include the amount of rent that's due and owing. In the last show, I mentioned something about additional rent clauses being in the lease. If you have the proper additional rent clause, you could tack on late fees, and you could tack on your legal fees and costs as well. And if the tenant does not show up at the trial with all of the money that's due and owing, that tenant can be evicted. Now, when you go to the trial, there's a couple of things that can happen. Number one, tenant shows up with the money, says, here it all, I'm sorry I was late, here's the money. Mm-hmm. Tenant stays no matter what. Number two, tenant says, okay, well, I'm sorry I was late, I got laid off, and I've paid before. Would the landlord be willing to enter into a payment plan with me where we can just work this out? And a lot of times I have a lot of good clients who they say that's not a problem, we're going to work on it. Mm-hmm. But if the tenant violates or breaches that agreement, now we can proceed with a lockout. Okay, mm-hmm. But they've now entered into a payment plan. Another thing a tenant could do is they say, listen, I'm sorry, I've fallen too far behind. I'm never going to be able to pay my rent. I'll go move in with so-and-so. Do you mind if I just leave at the end of next month? Mm-hmm. And we could put that agreement on the record as well. Mm-hmm. If the tenant doesn't leave, we proceed with the lockout process. The last thing that can happen is what the tenant complains about the condition of the unit. Tenant says, I didn't pay the rent because you didn't fix this. Mm-hmm. Now, when that happens, now the case gets a little bit more complicated. But the court, as a gatekeeper to those types of defenses, requires the tenant to deposit the balance owed with the court. So if you withheld your month's rent because the landlord didn't provide water or hot water or one of the essential utilities of the unit or heat, the tenant in theory should still have that money. So the court says, tenant, deposit that money with the court, and now we'll hold a hearing to see whether you notify the landlord and whether the landlord failed to comply. So a lot of times, because tenants come to court and they say, okay, I didn't pay because of this, but it has to be something that essentially affects the habitability of the unit, and the tenant has to have the money to deposit with the court. And then when that happens, you come back a different day for a habitability hearing, and the court will decide how much the tenant gets back and how much the landlord's entitled to.
And that's that famous case, right? Was it Marini or Ireland?
Marini case.
Marini case, yeah. See, Jane, you missed going to law school.
You're good.
Oh, yeah. Well, I know a little bit about it.
I read your bio. You're an attorney too.
Yeah. I know a little bit of, it's jack of all trades, I guess.
Engineer too?
Yeah, just a little bit. Yeah, I told you a little of this, a little of that. So
Dabble in brain surgery?
No, I didn't do that. Nothing medical. I don't think I'd be good as a doctor. I don't have the skill set with the hands yet to do that. But so that's really interesting. So the habitability standard, as I understand, is pretty stringent for the tenant to rightfully withhold rent. I mean, you got to be talking about like the rain going through the roof, lack of hot water, lack of heat. It can't be that there's, my kitchen floor is broken. It has to be something that really affects their habitability, I guess is the best way to put it.
Right. And when I get calls from tenants saying, what do I do? The answer is notify your landlord, and if the landlord doesn't comply, repair and deduct. Now you've shown on the record, you've put it in writing via email. I prefer email because they're easy to print out and you can bring them to court. I told you I don't have heat. It's been 3 days. It's the middle of February. We're heating our place with space heaters. Call your HVAC guy. Get him over, pay the bill, and say, by the way, my rent is $1,000 a month. My HVAC guy cost me $400. Here's your check for $600. Yep. And now the landlord's got to come get you, file for eviction, and then you're going to go to court and show the court why you didn't pay your rent.
Yep.
Yeah. So I was saying, I look at it as being two branches of the tree. That's the non-payment branch.
Right. Yeah.
Okay.
Before we move on, could you talk about then the lockout procedure? Because I just like the timing. Because as I understand it, if you win on the eviction, then you've got to wait and file like the warrant of removal. And could you actually talk about the warrant of removal?
Sure.
And then physically, if the tenant still doesn't go, what happens if the landlord and the fact they can't just change the locks, and how they'd have to actually get the court involved and the sheriff?
Of course. Yep. So you go to court. You get a judgment for possession. If the tenant doesn't show up, you get a default judgment. If the tenant doesn't have the rent, you go to trial, you get a judgment for possession. Okay? So you can't just lock the tenant out that day. You can't go and change the locks and say, I got you evicted, you're out. Right. What happens is, after the judgment's been entered, the landlord has to request a warrant of removal. The warrant of removal gets assigned to one of the court officers. Okay, we have a couple of great court officers in Middlesex County who are really busy and do their job well. And what happens is, once it gets assigned to the court officer will ultimately post the warrant of removal on the tenant's door, and that warrant will give them 3 business days to leave. Okay. If they don't leave, the lockout can be conducted. So, for example, warrant's posted tomorrow. It's going to say it's April 19th. They're going to say you got to be out by, let's say, Thursday, April 25th, or Wednesday the 24th,
Third
whatever
business
it is.
Day, yeah.
Right, third business day. What we do is we tell our client, we say, this is the court officer's name and number. Call them, find out when the warrant's posted, find out when the day is, and schedule your lockout now after the warrant expiration date. And you need the client has to arrange with the locksmith, because this court officer doesn't change the locks for you. Right. So the client has to be there, has to meet the court officer there with a locksmith, and then they do the lockout.
Okay. So the court officer has to be there for the lockout. They can't just wait till the expiration of the date, and then the landlord can't engage the locksmith without the court officer being present. No,
you can't do that, and it's also not safe for the landlord, right? If you have a combative tenant who's not willing to leave, that court officer is an officer of the law who can now require them to leave and call for police assistance. So now the next question is, what happens if the tenant leaves and leaves all their stuff behind?
Right. That was my father. Right.
Yeah. Sorry.
Sure.
Sorry.
You can read his mind.
That's you flip back and you can. Yeah. No,
that's the next logical question.
That is a question we always get from people: is how long? What do I have to do? Where do I have to put it? How long do I have to keep it in storage? All those questions.
You have to keep it in storage for 30 days. Okay. So when the tenant leaves, there is an act called the Abandoned Property Act, and there is a required notice that you have to send the tenants. It's easier if you just give it to them on the day of the lockout, or email it to them immediately. And just say, You have 30 days to remove your stuff. Any property left behind will be deemed abandoned. And during that 30 days, the landlord has to protect their stuff. Leave it in the house, move it to a garage, put it into storage. But either way, the landlord may not dispose of it other than perishable items. There's some nuances. If there's motor vehicles left behind, there's a different law that applies for that, if they're leaving stuff on the driveway. But, so the landlords, you've got the place back, but you still may not be able to necessarily fix it up and rent it right away. There's some work that needs to be done.
Sure.
When we do go to court with tenants and they agree to leave, one of the things that's important is we include a clause in the vacate agreements that basically say any property left behind is abandoned without further notice to the tenant. That way, on the final lockout day, if the tenant doesn't remove their stuff, it's gone.
Oh, so contractually you can override the state law.
Correct.
They're not going to. The court won't say that's unconscionable. You can put it in writing.
We try to put it into all our agreements, and tenants usually don't have an issue. And look, even if it's in the agreement, if the tenant's left some stuff behind, and the tenant's, says, "Listen, I'll come back tomorrow," you're not looking to hurt anybody, right?
Yes.
Right. At the end of the day, if I represent a landlord, whenever I go to court, my first approach and strategy is to always be super cordial with the tenants. And it's not until if I see all of a sudden a combative adversary and I'm like, oh, okay, all right, now we need to get a little stern and say, all right, you need to leave and when. But usually it's a lot of people who've fallen on hard times, and if you can't be an empathetic person who understands that people go through some hard times, I don't think you're even doing your landlord clients a major service.
Yeah, we all need the compassion.
I think it's important.
Yeah, especially if they're cooperating and they're trying their best, but they're like you said, they fell on hard times and they have to just reset their life. They have to pick up and go somewhere, even though it's justified. It's still a hardship for them too.
Yep, I don't want to say I'm fully a bleeding heart, but I'm a pretty empathetic human being.
Sure.
So it's not like I ever envisioned myself, I'm going to represent landlords for a living. Like I didn't think that was going to happen, but the way I sleep at night is knowing that I did it empathetically and tried to resolve a situation the best I could.
Right. I think every situation resolution, if the two parties can agree to a compromise and the settlement, if they can avoid court, it's always the best. It's usually the best scenario.
And sometimes there's kids involved, a lot of times. So
that's true. Yeah, we forget that too. Minors involved, so it's even harder for them they have to leave the school system and pack up and go.
I'm a parent. I get it.
Yeah. All right, that's a good break point. We're going to take a short break. We'll be right back after these messages. Okay, welcome back to our show. We're talking with Craig Rothenberg, an attorney, discussing landlord-tenant issues, and let's continue talking about landlord-tenant disputes. So before the break, we covered one of the first branches for actions for eviction, which does not require any notice. If the tenant doesn't pay the rent within, I guess, the 10 or 15-day period, then the landlord can go ahead and just file the paperwork or hire an attorney, and they can proceed with the eviction proceeding, which Craig very clearly documented prior to the break. So let's talk also about the other causes of action for eviction, which do require notice.
Right. So I was saying there's two branches of the tree, non-payment on the one hand, and then the other, we call it for-cause eviction. And for-cause evictions are more challenging. The statute requires certain notice requirements based on the cause that you are specifically asserting. And the way the statute is worded, it requires a little bit of deciphering to figure out exactly what notices are required. So let's go with like a couple of examples just to get an idea of what's required. So the first one would be, okay, I have a tenant who, no pet clause, right? And there's dogs and there's cat hair everywhere, whatever it is. They're violating it. What do? I want to end their tenancy. The first thing that you need to do when there is what we call a lease violation is you need to serve them with a notice to cease. And that notice to cease needs to very clearly tell them, your lease says no pets. Paragraph 14 of your lease says no pets. We visited your property, or the neighbors complain that there's multiple pets. Okay? You are in violation of your lease, paragraph 14. If you do not remove your pets within 30 days, we will terminate your tenancy. Okay, so that's your notice to cease. A lot of times landlords call me up and they say, I did my own notice to cease. Is that okay? And I take a look at it, and it's got to be very specific. So usually the landlords who do it on their own get it wrong. Okay? So now you've served the notice to cease. 30 days goes by. You go back to the house, pets are gone. Cause is over. Okay? Good. You've accomplished your goal. More likely than not, people don't just get rid of their pets. What's the next thing you do? Now, 30 days later, you serve a notice to quit. And the notice to quit terminates the tenancy at the end of the next calendar month. Okay? So usually the time period between the time when the landlord calls me up and when the notice to quit will become effective is usually about 3 to 4 months, right? Because you have to serve those 2 notices. Okay, so now, let's say today, served my notice to cease. End of May, I served my notice to quit, terminating the tenancy June 30th. Now it's July 1st, the tenant hasn't left. Now you can file for eviction. Right? So, right, it's a long process. You're probably not getting to court for a lease violation for 4 or 5 months.
Wow.
Right. So that's what it's going to take. Now, those are the requirements.
And
now,
the service is by certified and regular mail? Both, I have to send them, I would assume, right?
Right. That's the right way to do it. A lot of times, ideally, you have the tenant's email address and they're emailing you back and accepting service.
So you kind of establish that they've gotten the notice, yeah.
Yeah. I mean, the notice requirements in the court rules are a little antiquated at this point in the game,
with
unfortunately,
email
right?
Sure.
Sometimes if you have a tenant who's obfuscating, you go and just personally serve them. Pay the $100 for a process server to drop it off at their house. It's not a bad idea. Now, so that's a lease violation case. Now, let's say the other example that we used before is you want to terminate because you're selling the property.
Yeah.
There's no notice to cease that's required there. That's just your 2-month notice to quit. After that, you can file for eviction. So you're under contract today, terminate the tenancy June 30th, July 1st, you go and file. Okay. Now, you also want to make sure that your real estate attorney is knowledgeable about these issues because you want to be able to make sure that the contract doesn't fall through just because the place isn't vacant on June 30th. You've given yourself some wiggle room. Right. Saying, listen, we could sell, but we'll remove the tenant, or we're going to extend the closing date until the tenant's removed. Now, the more complicated ones, well, not more complicated, but let's say the more pressing matters are when you have a tenant that's destroying the property. Okay, you have a tenant that's causing repeated damage to the property, and there is a term in the Anti-Eviction Act that allows you to terminate a tenancy on an emergent basis on 3 days' notice. So you have a tenant who's physically destroying your property on purpose, right? It has to be, I think it's intentional, or it can be grossly negligent as well, causing willful destruction of property. So if the tenant's doing that, you can serve them with a 3-day notice to quit, after which time you can file for eviction and try to get to court as quickly as possible. Now, can I give you 2 examples?
Yeah, sure.
Okay. Sure. I'm going to give you 2 separate examples. One where it was deemed emergent, and the other where not so much. Yeah. So if you have a tenant that's really destroying the place, you're going to file a complaint, and then you're going to file an order to show cause asking for this to be scheduled for trial immediately. Like, my property is being destroyed irreversibly. I need to get to court. And if it lands in the right desk, you'll get your court date hopefully within a couple of weeks instead of waiting a couple of months, and you'll get before the judge. And that's important. And the courts, they're overloaded, but they do a good job with those applications. 2 examples, and both of them got different results. One of them, and this is the one I was telling you about before that we just completed, but this one, all sorts of problems with the tenant. The tenant wasn't even a tenant. The tenant was a squatter. The tenant canceled the lease, took a refund of the lease, but saw the code when my client showed her the unit and broke into the unit.
Oh, my God.
Okay, and then had to go through court to have her removed.
Right. That was another topic. That's a whole different topic.
That's a whole...
rights, which is now with the rights of squatters are treated as tenants, and so. But let's.
I don't want to go too deep into that case. But let's just talk about as it pertains to the damage issue. She started making excuses as to the place is damaged, and then my client found out that there was a sewer leak in the basement. Okay, so he said, "What do I do?" I said, "You need to get to that house ASAP, put some booties on, put on your hazmat suit, and you go in the basement and you wait until they snake that line, right? You wait." And what happened when they snaked that line? They pulled out towels out of the sewer line.
Oh, my God.
So she was intentionally making an excuse to not pay and to try to get him to pay relocation costs, right? So by flushing towels down the toilets.
So, that's a willful act of,
The court scheduled it for trial quickly.
Yeah.
We had a trial, eviction, and done. Case is over. Right, so that was emergent. That was severe. We had a trial. We had the Roto-Rooter guy testify as an expert as to what he found when he unclogged the sewer main.
Yeah.
Right. So that's one example. I have another one where my client claims that the tenant is housing chickens inside. She had chickens outside. We said remove the chickens. The chickens are gone.
Yeah.
But apparently the chickens might be roaming in a pen in the kitchen. We're not so sure. That's what we believe is happening.
Sure.
Court looked at it and said, this isn't exactly an emergency. We'll get you a court date, but you're not getting into a court date next week.
Okay.
So that's kind of the difference there.
Interesting. And in both of those examples, the landlord still had to give the tenant a 3-day written notice to quit.
Yep.
Wait the 3 days, and then they could go in there and then start the eviction.
That's right.
But another question was, what if sometimes the getting access to the unit may be an issue? In this case, I guess the tenant in the sewer case, I guess the tenant voluntarily allowed the landlord to come in and said, hey, there's a big issue with the sewer, and but if you could have a situation arise where the tenant is damaging the property and then the landlord doesn't know about it because they're never in the unit which is, I guess, a whole other back pattern. But
another one we get a lot is I want to sell the property and the tenant's not letting me show.
We get
you get that a lot.
And there's not much you can do.
Notice to cease, notice to quit takes 4 to 6 months to get to court. I mean, that's what you're locked in on. So, it just goes to show you, though, in nearly all situations, it benefits you greatly to try to have a cordial relationship with the tenant.
Yeah.
Listen, we're showing the unit. You have a lease till next year. You're not kicked out.
Right.
And if you don't have a lease, well, then you might be. But trying to get the tenant to cooperate is very important.
And sometimes what the landlords do in the addendums, they put in that, the tenant agrees in the event the tenant elects not to renew the lease, they agree to allow the landlord or their agents to show the property 60 days prior to the end of the lease term with reasonable notice of like 24-hour, notice to the tenant or something like that.
But once again, that clause doesn't mean that the tenant has to leave again.
That doesn't mean they have to leave.
Right. That clause, they're still going to go month to month if the tenant overstays.
Right.
Right, so
that goes back to last week's show where you talked about the month to month, and then the tenant still has the rights, unless of course the landlord has good cause for. But if they're selling it, like just to recap last show, if they're selling it to a buyer that intends to self-occupy it, then they could, I guess go through the eviction process.
That's right.
The contract in hand, and they would just delay the closing date. But that's why the landlord-tenant lawyer and the real estate attorney have to be on the same page.
That's right. The other most common one we get is the landlord saying, "Listen, I'm retiring. I want to be done with this property. Yeah. I don't want to rent it out anymore." Something like that. They're not, whether or not they're converting it, something like that to maybe another use, commercial, something like that. And that is an 18-month notice to quit. So if you are planning on doing that, if you think you're going to do that, year and a half.
Wow. Year and a half?
18 months. I never even know there was such a long, wow.
Yep.
That's something.
Wow.
That's a real interesting, 18 months. So it's not considered a hardship unless can the landlord try to say that it's a hardship. I really need this money. I'm moving out of state. This one rental unit is my only asset. And can they try to shorten that time frame by trying to argue that they're in financial hardship?
I don't think so, because the landlord's recourse there is to sell. Right? If the landlord's moving out of state, there's a difference between retiring it for residential use versus, I'm just moving, or I want to not rent.
I don't want to be bothered because I'll be out of state.
Right. In that case, it's you're going to sell the property, or you're going to get a property manager.
Yeah, and deal with it. Okay, Craig, we are out of time. Thank you so much for being on here. We had you last week, this week. We still have a lot to cover. You're going to have to come back again. But once again, for our listeners, please give your contact information.
Thank you very much. We're the law office of Craig Rothenberg. We're located at 93 Bayard Street in downtown New Brunswick. You can call us at the office at 732-247-5002. You can visit our website for more information at www.rothenbergesq.com. Please give us a call if you have any legal questions. We are here to help. Thank you for having me. It's been really fun. Thanks.
We learned a lot.
We
Thank
learned
you.
a lot, and thank you so much. We'll see everyone next week.
Thank you.